Okay. Yes, sir. Okay, sir. Yes, Your Lordship, I'm taking a listing of the IA criminal lordship. IA criminal lordship, Pradeep Jha matter, lordship, this ISRG is fixed on 23rd of January, lordship. If possible, tomorrow, 19th.
What is fixed on 23rd January?
Is eye surgery, lordship. Eye surgery.
Day after tomorrow. Day after tomorrow.
Of lordship.
It is for orders item 1.
Lordship, this matter relates to that border issues between Mizoram and Assam.
Border issues means
Means, my lord, there are encroachments and destruction of forest land inside Assam, my lord. So, your lordship, our prayer was that, my lord, your lordship may pay with our prayers, my lord. At page 7, my lord. Directing the respondent authorities to put in place a proper mechanism for immediate recovery and eviction of the trespassers from the forest land of so-and-so village under so-and-so. Directing the respondent authorities to put in place permanent mechanism to ensure protection of the forest wealth and to prevent miscreants from causing destruction to such forest wealth in the bordering areas of state of Assam, including the areas bordering Mizoram, Meghalaya, and Arunachal Pradesh. My lord, the affidavit filed by the state forest department, they have also admitted that there is enforcement, my lord. Still there is enforcement, my lord, and destruction of forests. Forest affidavit filed by the
so this PIL has been admitted.
yes, my lord.
Yes, Lordship.
Yes, my lord, it has been admitted.
By which order?
So actually, Lordship, as of now, Lordship, what is happening is that there are several ministerial level talks have already happened, and it's going in the right direction. That some resolution we can foresee, Lordship, in the coming months. So there are a couple of other similar matters, Lordship. That incident happened, if your Lordship recollect, that in the Assam Mizoram border, there are 2-3 other PLs which have been already filed and they have been already disposed of. Because these talks are going on, high level talks are going on, at this stage court refrained from interfering, the honorable court. So in this matter also, Lordship, this is if they insist on like it's a typical border issues, then Lordship, they'll have to approach interested borders, they'll have to approach Supreme Court. Otherwise, Lordship, at this stage, Lordship, I'll leave it to your Lordship, but like high level talks are going on, Lordship. So some resolution we can foresee in a couple of months. Because there are several Lordship allegations and counter allegations between these two states.
So, Mr. Bora, what is the direction you are asking from the High Court?
My lord, regarding the protection of the forest land and forest area, my lord, because border dispute is not the issue in the PIL, my lord.
So, are you alleging that the state government is not doing anything to protect the
My lord, the affidavit filed by the forest department, they have admitted that there is enforcement and destruction of forest, and they have taken some steps also, my lord. But still there is enforcement, my lord. Enforcement and destruction of forest property, my lord.
He is saying there are attempts to resolve the issue.
Yes, my lord.
Yes,
that is
Lord.
true.
Then,
But our issue is not the border issue, my lord. The issue in the PIL that we have raised, my lord, it is not the border issue.
encroachment by whom?
By the people from the Mizoram, my lord. And in the affidavit filed by the forest department, they have also stated that the people from Mizoram side, they have come over and encroached and destructed forest land, my lord.
The
Forest property. my
state
lord.
of Mizoram is denying that. The issue is that state of Mizoram is vehemently denying this. State of Mizoram is saying that there is no encroachment done by any Mizos in the state of Assam. There is a stand.
You are appearing as,
I am appearing with additional AG Mizoram members.
so what can be done here? These are interstate matters. I think the government will be in the best position to resolve it. What order can be passed by the High Court?
So last
My
lordship,
lord, let the matter come after 1 week, my lord. I will obtain instruction from client also, my lord, regarding the present status and what.
the Union
Or
Home,
your
Union
lordship
Ministry.
may pass appropriate order as your lordship may think.
In fact, lordship,
for the
Indian
state?
Ministry is also involved.
Hmm.
And Secretary, Home Secretary is also involved in couple of discussions. And last September, November only, one meeting happened here also. And they have filed an affidavit also with that. To that context. Yeah. Okay.
Who is appearing for the state of Assam?
I'm appearing for the forest department.
Yes, what do you have to say?
There was some encroachment
Hmm.
and we took steps to evict the encroachers. And during COVID-19, because that area could not be patrolled properly, there was some re-encroachment. And while trying to evict those encroachers, there was some dispute with the force, security personnel from Mizoram. That was the issue.
Mhm.
And presently, your lordship, my instructions are also that there is a high-level talks going on at the highest level of the executive for resolving the issue. And otherwise, because that area is disputed, it will fall under Article 131 before the Honorable Supreme Court, your lordship.
We will not get into all these things. Mr. Dev Chaudhary. No, Mr. Bora, you have flagged the issue. You have flagged it,
Yes, my lord.
but resolution lies in the domain of executive. All right, because it has got an element of interstate border dispute. That is why we'll record their assurance and close the matter today. Yes,
Lordship, so far as the union government is concerned, Lordship, steps have been taken to have talks with both parties, Lordship. Lordship may see my affidavit in March 2021. In paragraph 2, subparagraph 2, I have stated, and even Lordship, my instruction is that Lordship, some talks are going on between the parties and at the behest of the central government, Lordship. Both the parties have come together to resolve the issue, Lordship. And in fact, Lordship, both states claim the same territory to be theirs. That is the prime issue, Lordship.
you take down third Mr. D.P. Bora, learned counsel appearing for the petitioner. We have also have Mr. A. Kalita, learned additional advocate general state of Mizoram, Mr. R.K. Dev Chaudhary, learned DSGI, the postal
For 1 and 2.
appearing for. So then Mr. Kalita for restaurant numbers
Section number 4, 7, 12, and 13.
4,
7, 12, and 13.
4, 7, 12 and 13. Mr. Dev Chaudhary for restaurant number 1
1 and 2, Lordship.
and Mr. KP Pathak, learned standing counsel
Forest department for respond numbers 5, 14 and 15.
5, 14 and 15. Remaining respondents are not present before this court today. In this PIL, the primary grievance of the petitioners is on account of the fact that the land belonging to the Forest Department, Assam, situated in the border, in the state border between Mizoram and Assam, is under encroachment of people belonging to the, you write like this, land belonging to the Forest Department, Assam. Has been encroached by people belonging to the state of Mizoram, and despite being aware of the said fact, the state government has not taken appropriate steps for evicting the encroachers from such land. Full stop. Mr. Kalita, learned additional AG Mizoram, submits that the state is disputing the stand of the petitioners to the effect that the forest land of Assam is under encroachment by people from the state of Mizoram. Full stop. However, according to Mr. Kalita, the larger issue involved in this matter is interstate boundary dispute, and efforts are on at the highest level. And according to Mr. Kalita, efforts are on at the highest level to resolve such dispute. Full stop. Expressing hope that some breakthrough will be achieved in the matter in near future. The learned additional AG submits that at this stage, no order is required to be passed in the matter by this court. Full stop. By referring to the affidavit filed on behalf of respondent number 2, Mr. Dev Chaudhary has also supported the contention of Mr. Kalita by submitting that there is an interstate boundary dispute which is being looked into at the level of Union Home Ministry with the participation of both the states governments and therefore the state governments. Full stop. Since the issue is sensitive in nature, no order is required to be passed in this case at this stage. Full stop. Mr. KP Pathak, learned Standing Council, Forest Department, Assam, submits that although he is not denying encroachment of forest land, yet considering the impending border dispute between the two states and the steps initiated at the highest level, he is not in a position to make any further submission in the matter. Full stop. We find that on 8/3/2021, the respondent number 2 has filed an affidavit making the following statements in para number 2. You quote para number 2. Double tick to double tick. Full stop. From the stand taken by the respondent number 2, it is apparent that there is a border dispute between the states of Assam and Mizoram, which had led to violent clashes between the people living on either side of the border. Full stop. The affidavit also mentions about law and order issues, which is required to be resolved by the respective state governments, and the fact that the Ministry of Home Affairs is looking into the matter for restoration of complete peace and amity between both the sections of the people. Full stop. A bare reading of the aforesaid affidavit, considered in the light of the submissions made by learned counsel for the parties, leaves no room for doubt that this is not an ordinary case of encroachment of land, but is a dispute regarding the, but is a interstate boundary dispute which has to be resolved at the highest level by giving utmost importance to the maintenance of peace and law and order in that area. Since the respondents' counsel have assured this court that the matter will be resolved soon, through an amicable process at the intervention of the Home Ministry, Ministry of Home Affairs, Government of India, with the assistance of both the state governments, we do not deem it appropriate to keep this PIL pending before this court any further. Full stop. However, after the interstate boundary dispute is resolved, if the petitioner continues to feel that the state forest department has not initiated appropriate steps for removing encroachment of forest land, then it will be open for the petitioners to approach this court afresh, once again by filing fresh petition. With the above observation, we close this hearing.
Obliged.
Democracy order dated Q1 2023. The certain government is directed to file an affidavit. We received the instruction, we send it the affidavit for vetting, but the hard copy yet to receive. But so can you please after 10 days?
Yes or no, say.
Your lordship may kindly.
Either you say that forget the affidavit, let's finally hear the matter today. Or you say yes, you can't vacillate in between. That gives
Let
time,
them-
but I have objection. That kind of approach will not work here.
Let them file, madam.
Let them file, okay. 10 more days time to bring the affidavit. You are for the,
That's one 7.
all right. Heard Mr. R. Ali, learned counsel appearing for the petitioner. Also heard Mr. D. Nath, senior government advocate Assam, appearing for the state of Assam. Mr. U.K. Goswami, learned central government counsel, has appeared for the respondent number
1 and 7.
1 and 7, respondent numbers 1 and 7, and submits that although the affidavit has been sent for vetting, yet the signed copy, bracket hard copy of the same has not been returned back till today. Full stop. On such ground, Mr. Goswami prays for posting this matter again after 2 weeks, so as to enable him to bring the counter affidavit on behalf of the Union of India on record. Full stop. Since the prayer is not opposed, same stands allowed. Register to list this matter again after 2 weeks. In the meantime, the parties to exchange pleadings.
Obliged.
This my lord, I was directed to file affidavit about the status of the progress, my lord. In the during verification, I have received my instruction, my lord. Also allow me 10 days.
Status
time
of the progress, what is the
the
matter
wa-
about?
Water supply in Guwahati.
Water supply in Guwahati. Where is the water?
Wow, it's coming.
Everybody is
I
crying.
have filed my affidavit, it's coming, my lord. There is lots of difficulties we have faced because of the vendor who had ultimately abandoned our project. We have engaged other persons to complete the, we are already filed an
No,
affidavit.
but when are you going to give
I
water?
have filed the affidavit by March 2024. It will be entire 100% will be done. Already I have filed my affidavit.
March, which date of March?
Month of March 2024.
Month of March, 1st March.
We'll try to make it 1st March, my lord. But we have filed March 2024.
When will you file your affidavit?
That's progress report, my lord, we'll file after 10 days, my lord. I have received it, my lord.
No, why 10 days you want?
My lord,
Water is important.
water is important, my lord.
You don't want water to be,
Lordship.
then
But the progress report from the last order till date, my lord, that affidavit, my lord. I have received my instruction.
May I just invite your lordship's attention to one order, Millard, of 22nd of September 22, Millard.
yes, 22nd of September.
22, Millard. Lordship may kindly come to the second paragraph of the order.
Just a minute.
Yes,
22nd of September, you said?
Millard.
Yes.
Let me come, can we come to the second paragraph? The affidavit filed in pursuance of order dated 8th August 22 as such does not answer the real question raised in the petition. From the record, it can be seen that time and again affidavits are filed in the proceedings to bring on record the status of the progress made as regards the two important aspects raised in the prayer portion by the petitioner. The state government shall file a detailed affidavit to an officer of the level of secretary of the concerned department stating therein as to what are the plans of the government or its authorities, including the Jal Board and EMDA, for supply of potable drinking water to the citizens of Guwahati city. The concrete plan, phase-wise, and the time schedule shall also be a part of such affidavit. The affidavit as directed shall be filed on so and so. Now, my lord, may kindly come to your lordship permits me, may I just show a couple of paragraphs from two affidavits which have been filed, my lord. So the multiple affidavits have been filed, but I would like to invite your lordship's attention.
All
to
right,
an
so
affidavit.
today, what is the order you're seeking?
Well, today, my lord, I wish to place, my lord, that the affidavits that have already been filed are completely silent on two phases, my lord. One is the southeast and one is the southwest, my lord. Completely silent. In fact, they have admitted that there are no funds, my lord. And there is also there is complete silence regarding the progress, my lord. In fact, the contractor who was assigned the work, the contract also stands terminated as on date, my lord. So, my lord, in my respectful submission, at least for these phases, if your lordship may kindly consider appointing a committee to look into the aspects which are holding these particular phases, my lord, behind. Central, there has been some development is what they are claiming, my lord, and I'm not disputing that, my lord, in the writ petition. I don't want to go into disputes, my lord. But, my lord, at least on these particular phases, my lord, the southwest and the south central, my lord, if your lordship may kindly just peruse, my lord.
All right, you're Mr.
Abir Pukan, my lord.
Acha, Mr. Pukan,
In fact, I'm suggesting
you
also. my lord,
have a
few-
little patience, we'll now handle it. This is not an adversarial litigation.
It is not, it is not. It is not.
We do believe and trust that whatever has happened in the past, at least now, there are sincere efforts. But that effort has to receive further shot in the arms.
Lordship, we'll
So
expedite the process.
you tell us, we'll fix a date. Within that date, you file an affidavit, give a complete plan, and also the fund position. Fund position, whether you have the requisite funds or not, you indicate those things and place it on record. We'll give you 1 week time to do that. You serve advance copy. After 10 days, we'll have the matter.
Lordship,
Let us see what is happening.
Lordship,
In
If
fact,
there
the
is any
affidavit-
issue which requires to be resolved,
Lordship,
we'll do it.
Lordship.
We'll do it. And we don't think that you are not working.
So we have already given the concrete plan, and after the 22 September order, we have given a concrete plan. Only thing is that process. how it is going.
When are you going to give water to the people? What
No.
are your plans? Do you have the funds? These three
Yes.
things.
Lordship, Lordship,
Just if your lordship may allow me half a minute, my lord, just one paragraph of the last affidavit which they have filed, my lord. This is an affidavit which they filed on November
Mr.
22nd.
Pukan, we will give you half an hour, not half a
I don't want
minute.
to address arguments, my lord. Just I want to
But
bring your lordship's
what is the
attention.
point? Since we are going to give him 7 days time, what is the point?
My lord,
Tell
let
us the
let
point.
file. I'm not, all that I'm saying is that, my lord, they admit that the contract with Gammon India stood terminated, my lord, at para 3 of the affidavit. And my lord, they have stated in the affidavit that plans are being formulated for the balance project work to be completed and tender document is being prepared in this regard. So this is the position, my lord, insofar as Southwest is concerned. So, my lord, after the contracts to terminated.
Which
now
part is
tender-
southwest? Which is southwest?
My lord, Southwest.
Which are the areas which comes under
Well,
southwest?
Sadalipur is one of in fact, they had started the treatment plant there, my lord, but very minuscule areas have been
Mr.
covered.
Pukan, you see, while we appreciate the urgency, the requirement, and it's really a pity that in a city like Guwahati, people are having to move PILs to get drinking water. It's really a pity.
Absolutely.
Somebody somewhere has miserably failed.
And year after
We'll
year.
see
we are
all
in the
these
news,
things
my lord,
later,
for
but-
water logging and floods, my lord. And
At the moment, what is important is to facilitate the supply of water at the earliest,
I bow
instead
down.
of getting into the legal issues.
I bow down. my lord.
We'll see how the legal issues are to be
Yeah, all
reduced.
that I'm trying to lay down emphasis is on, my lord, South Central and Southeast. Southeast is completely silent. It doesn't even find mention in the affidavit, the two last affidavits which they have filed. In fact, your
Mr.
lordship.
Bora, you
Lordship, Lordship, I'll.
file an affidavit indicating all these
Lordship,
things.
we will find it.
And who's the managing director of this?
That's
Jalbur.
another important, interesting aspect. You know, the managing director was appointed in September
Hmm.
21. In April 22, he tendered resignation.
Now is the,
After that,
now is
Millard,
the
the
present.
DC,
Yes.
DC Kamrup Millard is
Please
in
second.
charge, Millard, who's overburdened with so many
Oh,
administrative.
that is not your problem, overburden.
It is not Millard.
That is their governance issues. We are not going to get into that.
But as of now, Millard, subject to correction, there is no managing director, Millard.
No, he is the managing director, DC. Mr. Jha is the managing
Which
director.
DC? DC Kamrup.
DC Kamrup. He also looks after the Jal board.
So we want an affidavit from the managing director.
Lordship, lordship.
Let it come. Let us have a clear picture. We'll see if there is something the court
Yes.
needs to do.
Lordship.
And we are again and again indicating, we don't think you are not working.
Hmm.
But then some things have gone terribly wrong in the past.
Yes, that's,
This is a
that's why
pity.
it is coming.
This is a pity that the citizens of this
No.
great city are begging for water in the 21st century, in the year 2022-23. Somebody is terribly messed it up.
No.
Who has done it, we'll see.
No.
Take down, heard Mr. A. Pukan, learned counsel appearing for the petitioners. Also heard Mr. S. Bora, learned standing counsel,
I was paying for GMDA, GMC and Jal board
GMDA, GMC
and Jal board.
and Jal board appearing for respond numbers
3, 4 and 5.
3, 4 and 5. Mr.
I am for 6 Lordship.
Mr. K. Gogoi, yes, you are appearing as government advocate.
CGC Lordship for central groundwater.
And as CGC is present on behalf of respond number 6.
Lordship.
Mr. KP Pathak, learned
Standing Council PHC,
standing counsel PHE has appeared for respond
number 2.
number 2.
Want to comment it?
By filing this public interest litigation bracket PIL, the petitioners have flagged a burning issue facing the entire city of Guwahati, that is shortage of waters,
Drinking
Well,
water.
potable drinking water, full stop. It appears that despite a number of projects being floated by the government, the citizens are yet to get proper supply of drinking water, full stop. Mr. Fukan submits that not to speak of furnishing water to the citizens, there is not even a concrete plan in public domain as regards the measures initiated for supplying water to the southwest and
Southeast, Millard.
southeast areas of the city coming within the GMDA area, correct?
Phases of the project, Millard, I think.
Uh,
they have divided.
As well as the progress made in the phases of the project being implemented for other parts of the city. Right? Full stop. According to Mr. Fukan, there is no clarity as regards the fund availability as well as the timeline for completion of these projects. Full
As
stop.
well as contractors, Millard, who are actually working.
Refuting such argument, Mr. Bora submits that work for making potable drinking water available to the nooks and corners of the city are going on war footing, and the department reasonably expects to make such supplies available to the citizens by the end of March 2023. Full stop. And Mr. Bora,
2024, my lord. 2024.
2024.
Lordship. Yeah.
March 2024. Full stop. Mr. Bora prays for a week's time to file a detailed affidavit indicating all such facts, including those features which have been mentioned in the order dated 22/9/2022 passed by this court. Full stop. Prayer is allowed. We make it clear that the affidavit shall be filed by the managing director of Jal Board, laying down the following aspects. Number 1, the timeline, the progress made in the work for supplying water and the timeline for completion of this same. Number 2, the availability of funds for execution of the projects. And number 3, interim arrangement, if any, being made by the authorities for supply of drinking water to the citizens. Full stop. The affidavit be filed on or before
My lord, one request.
24th of January 2020. 24th.
One request, my lord, I'm not based in Guwahati, my lord. May I request for 8th of February, my lord, for listing the matter?
Acha, then we'll give him 2 weeks time. 2 weeks time to file affidavit by serving advance copy upon the petitioner's counsel. Full stop. Registered to list this case again on 8/2/2023 as a fixed item.
Deeply obliged.
Item 3 and 4. Item 4 and 5.
Item number 4 and 5 arising out of same judgment, Lordship. May I pray, Lordship, I may be allowed to start the case for, I am appearing in item number 5, Lordship. That is for Sukumar Musahari. My learned friend is appearing for Munna Musahari, Lordship. No problem.
Ready? Yes.
Your Lordship, 2 appellants are convicted under section 20B(2)(c) of NDPS Act and sentenced to 12 years of rigorous imprisonment with 1 lakh rupees fine.
Conviction is under which section?
Commercial quantity, Lordship, 20B(2)(c). And FIR, your Lordship, will find at page 4. Page 4 of the paper. May I read?
Hmm.
Sir, with due respect and humble submission, I beg to state that today on 12/7/2018 at 10 AM, an information was received from IC Sonai Khawarang that 2 persons with a light vehicle Centro coming from Bhutan towards Udalguri carrying suspected cannabis. On the basis of the information, I, along with my staff and IC Sonai Khawarang, conducted a Naka checking in front of Sonai Khawarang PP, and during checking, the below noted accused persons are caught red-handed with 3 packets bosta suspected cannabis ganja 60 kg, which was being carried in the vehicle bearing registration number Centro Jing. The vehicle and recovered suspected cannabis were duly seized by preparing seizure list. So Lordship will find bottom your faithfully Jotin Chandra Deka, SI of Police, Udalguri Police Station. But it is not correct. He is not from Udalguri Police Station. He is from IC of different in outpost, Lordship. That your Lordship will find in his evidence. The Lordship will kindly see now page 7. PW1, that is the informant. I am the informant of the case. I know the accused present in the dock. On 12/7/2018, I was posted at IC Bhairavkunda Police Outpost. The Lordship may only noted that he is the IC of Bhairavkunda Police Outpost, but incident occurred in different outposts, Lordship. On that day, at around 10 AM, I received information from IC Sonai Khawarang, SI Gyasuddin, he is PW10, SI Gyasuddin Ahmed, that 2 persons in a Centro car coming from Bhutan towards Udalguri carrying suspected cannabis, ganja. On receipt of the information, I recorded Bhairavkunda GD number 179 dated 12/7/2018, and along with my staff and IC Sonai Khawarang conducted Naka checking in front of Sonai Khawarang Police Outpost. Just here pausing for a moment, Lordship. Here from the FIR and from this part of his evidence, it appears that he was part of the raided team. But subsequently, something else will appear, your Lordship will see. Just I am pointing out this aspect, Lordship. We conducted a check upon the Centro car where the present accused persons were traveling and found 3 packets suspected cannabis weighing 60 kg. On being asked, the accused persons disclosed their name as Sompur Musahari and Munna Musahari. We recovered the suspected cannabis, which was kept inside the Centro car.
On being informed that DSP Moidul Islam authorized me to seize the contraband cannabis ganja. Accordingly, I waited the suspected cannabis ganja at the place of occurrence in presence of witnesses and seized the same at the spot. I also took samples from the seized suspected cannabis ganja weighing about 24 grams each in 6 different packets for sending the same for FSL examination. Lordship may kindly note that he took 6 packets of packets weighing about 24 grams, which is subsequently turns to be 3 packets. And there is no number in the packets which were sent for FSL examination, Lordship. The said samples were also sealed at the spot in presence of witnesses. I also seized the Centro vehicle at the spot. Thereafter, seized material along with the accused were brought to the Udalguri PS and handed over to OC Udalguri PS. In this regard, I lodged an FIR with the OC Udalguri PS for taking necessary steps. Exhibit 1 is the FIR, Exhibit 1.1 is my signature, Exhibit 2 is the GD entry, wherein Exhibit 2.1 is my signature. Exhibit 3 is the authority letter, Exhibit 3.1 is the signature, Exhibit 4 is the seizure list of measuring scale and weights. Exhibit 4.1 is my signature, Exhibit 5 another seizure list of mini digital weight machine. Exhibit 5.1 is my signature. Exhibit 6 is the seizure list of 3 packets of suspected cannabis ganja. Exhibit 6.1 is my signature. Now cross. I reached the Sonai Khaurang police outpost at about 10 a.m. The vehicle in which the accused persons were carrying the suspected cannabis ganja had been detained by the IC Sonai Khaurang in front of the Sonai Khaurang police outpost. When I reached there in the place of occurrence, at the time of search and seizure, at the place of occurrence, no senior gazetted police officers were present. I lodged the Ejahat. I did not take the signature of the IC Sonai Khaurang as one of the witnesses of the search and seizure of the contraband cannabis ganja. In the Exhibit 3, the authorized letter issued by the DSP, the time and date of issuance have not been mentioned. Near the place of occurrence, there are many dwelling houses, including schools. I joined independent witnesses of the locality at the time of search and seizure of the contraband cannabis ganja. I did not send the copy of GD entry to my superior officer. I have not specifically mentioned the nature of the packets in which the seized contraband cannabis ganja had been kept. I seized the suspected cannabis ganja from the Sonai Khaurang police outpost. So he seized the same from the outpost. And he has not sent the copy of the GD entry to his superior officer, which is violation of section 42 subclause 2 of NDPS Act. Now page 9, PW2. I know the informant. The accused person present in the dock are not known to me. The occurrence took place on 12/7/2018 at around 10 a.m. At that time, I was at my jewelry shop. In the meantime, the IC Sonai Khaurang outpost came to my shop and seized my electronic weighing machine and weighted suspected cannabis ganja kept in 3 packets in my presence. And I put my signature in the seizure list. So PW2 says about 2 packets, 3 packets. But here the PW1 who took the samples, he said he took 3 packets, 6 packets.
No, these are 2 different things. Please don't confuse us. That is the sample of 24 grams.
Yes,
Six
Yes.
packets of sample.
yes, 6 packets.
This is the main seizure of the articles, the contraband. There is no confusion, no contradiction here.
No, it will later on I will clarify from the evidence itself also. And I put my signature in the seizure list. Exhibit 4 is the seizure list of weighing machine and Exhibit 4.2 is my signature. Exhibit 6 is the seizure list of suspected cannabis ganja. Vehicle, 2 mobiles and cash amount of rupees 3,800. Exhibit 6.2 is my signature, crossed by defense. I put my signature in the seizure list at Sonai Khaurang OP. The seized cannabis ganja were kept under packing at the time of seizure and the same were not shown to me. I do not know where from those sacks were brought. PW3. I know the informant. I do not know the accused persons present in the dock. The occurrence took place in the month of March or April in the year 2018. At the material time, one day I was coming from my home to Udalguri. At that moment, the police of Sonaigaon police outpost.
You're reading PW?
3, page 10.
Yes.
I know the informant. I do not know the accused persons present in the dock. The occurrence took place in the month of March, April in the year 2018. At the material time, one day, I was coming from home to Udalguri. At that moment, the police of Sonaigaon police post under Udalguri PS accosted me and asked me to come to the Sonaigaon police post as contraband cannabis ganja had been recovered from some persons. Accordingly, I proceeded to the police post and one police officer, after showing me suspected cannabis ganja in 3 paper packets, asked me to put my signature in the seizure list. Police showed me the suspected cannabis ganja by opening the packets. After preparation of the seizure list, in respect of the seizure of 3 packets containing contraband cannabis ganja, I put my signature in the seizure list. Exhibit 4 is the seizure list of weighing machine wherein Exhibit 4.3 is my signature. Exhibit 5 is the seizure list of mini digital weighing machine in which Exhibit 5.2 is my signature. Exhibit 6 is the seizure list of 3 packets suspected cannabis ganja along with 1 vehicle Centro Jing bearing registration number so-and-so. Exhibit 6.3 is my signature therein. Crossed by defense. I do not know as to where from the police recovered the 3 packets containing contraband cannabis ganja as shown to me. There were many vehicles inside the Sonaigaon police post, and the police did not show me the car specifically where from leaves like suspected cannabis ganja purported to have been recovered in a jute bag. The 3 packets which were shown to me were not were weighted in my presence. So here, Lordship may kindly note that in last part he says, last second line, Lordship, in prose, police did not show me the car specifically where from leaves like suspected cannabis ganja purported to have been recovered in a jute bag. There is discrepancy in the number of bags, because the person who initially apprehended, he says 2 bags. The PW1 says 3 bags. Here, PW3 is saying about 1 bag. Later on, your Lordship will find other seizure witness. They also speak about 1 bag. That is why I am pointing out here, Lordship. PW4, here also your Lordship will find about that. Domboro Sharma, PW4, page 12, Lordship. I know the informant as well as the accused persons present in the dock. The incident occurred 7-8 months ago. At the material time, one day I went to Sonaigaon police post for NRC duty. At about 11 AM, I saw some suspected cannabis ganja in a jute bag had been kept in front of Sonaigaon police post. Police gathered there also. Police gathered there also said that the substance might be contraband cannabis ganja, but I was not sure about it. I saw the accused persons in the veranda of the Sonaigaon police post. I was asked by the police to put my signature in the seizure list, but I did not put my signature in any seizure list. Crossed by defense. The NRC office is also situated along with the Sonaigaon police post, and many other people also visit the NRC office. I do not know as to wherefrom the jute bag containing dry leaf-like substances had been brought to the police post. The signature shown in the seizure list below, my name did not put by me. PW 5. Akash Mojumdar. He is the owner of the said vehicle. I know the informant and the accused person. The occurrence took place on 12/7/2018. On that day, I was not at home as I had gone to Siliguri to purchase some goods. While I was returning from Siliguri and reached Rauta Sariali on 13/7/2018 in the morning. In order to come to my home from Rauta Sariali, which is 25 kilometers away from my home, I telephoned my wife to send my Centro vehicle to pick me up from Rauta Sariali to my home. Then my wife replied that on 11/7/2018, one Nirmal Setri, he is not an accused, and what happened to him, nothing is there on record, Lordship. One Nirmal Setri came to my house and asked her to give the car to him to take his ailing father to medical for treatment, and the Centro car yet to be returned by Nirmal Setri. So my wife Meneka Rai went to take me from Rauta Sariali in my scooty. When my wife reached Rauta Sariali, she told me that while she was coming from home, one police officer of Sonai OP asked her to visit the Sonai OP. While returning from Rauta Sariali, we first entered into Sonai OP. At the police outpost, I was told that my car was seized by them due to carrying of contraband cannabis ganja therein. The police recorded my address, etc. Then we allowed to go out to our home, crossed by defense. When I came to the Sonai OP along with my wife, I did not see the accused persons present there. I also did not witness any suspected cannabis ganja at the police outpost, nor I was shown such substance by police. My wife told me that my car was taken away by Nirmal Setri. Page 14, Lordship, PW 6, wife of PW 5. I know the informant Jotin Deka. I know the accused Munna Musahari. Other accused person present in the dock is not known to me. On 12/7/2018, at around 12 o'clock in the night, one Nirmal Setri Thapa came to my home and asked me to lend our Centro vehicle to him to take his seriously ailing father to hospital. Accordingly, I handed over the key of our Centro car to him. In the morning, one police officer named Ahmed came to my home and told me that our Centro vehicle had been kept at Sonai police outpost and I was asked to present there. At this stage, further examination in chief was reserved by order dated 5/4/2019. Page 15. When the vehicle was hired by Nirmal Setri alias Thapa, accused did not came to our home. Nirmal Setri came with his wife, crossed by defense. I do not know as to how the police came to seize our vehicle. I do not know how our Centro vehicle was brought to police station. At that time, I saw neither Nirmal Setri nor the accused at the police station. I do not know what was recovered from our vehicle. Police also did not show me any article at the police station. Now, PW 7, page 16. Also. Neither the informant nor the accused persons present in the dock are known to me. About 1 year ago, the police of Udalguri PS came to my jewelry shop. Police asked me to hand over my mini digital measuring scale and also asked me to accompany them to the Udalguri police station along with the digital measuring scale. Accordingly, I went to the Udalguri police station. Police measured 4-5 small packets containing suspected cannabis ganja kept in envelopes in my presence. Police, after completing the measuring of the said packets containing suspected cannabis ganja, returned my digital measuring scale to my Jimma. Thereafter, I left the police station. Exhibit 5 is the seizure list and Exhibit 5.3 is my signature, crossed by defense. It is not known to me as to from which place the police brought the seized cannabis to ganja to the police station. PW 8, 17. On 16/7/2018, while I was posted as Joint Director, Drugs and Narcotic Division, Directorate of Forensic Science, Assam, Kahilipara, Guwahati 19, by memo number so dated 13/7/2018, I have received one parcel per messenger which was received on 16/7/2018 in connection with Udalguri PS case number 153 of 2018 under section 20B NDPS Act. The parcel consists of 3 exhibits. This is what I was submitting for your lordship. He said he took samples of 6 packets and thereafter he handed over to the OC and only 3 packets were sent for FSL. There is no numbering. I will show to your lordship subsequently. The parcel consists of 3 exhibits enclosed in a seal envelope cover. The facsimile of the seal was found to be SP UDL. Description of articles. 3 sealed envelopes marked as Exhibit A, Exhibit B, and Exhibit C containing 25 grams dry plant materials, each marked here as DN so and so. Dry plant materials. This is also important because I will show your lordship the definition of ganja and cannabis. Those are 2 different things. If it is a fruiting top with seeds, then it is not ganja, lordship. That I will place before your lordship. So here it is mentioned as containing 25 gram dry plant materials, each marked here as DN so and so, respectively. Result of examination. The exhibits DN so and so to DN so and so gave positive test for cannabis ganja. My report was forwarded by our Dadan director. Exhibit 7 is my report. Exhibit 7.1 is my signature. Exhibit 8 is the forwarding report. Exhibit 8.1 is the signature of Dadan director KC Sharma. I know his signature. Now crossed by defense. I have sent back the remnants of the sample to the forwarding authority. I have not specifically mentioned about the flowering top and fruiting top of the sample. This is required. I mentioned as ganja, which signifies both flowering top and fruiting top. So this report is not conclusive. Page 19, lordship, PW 9. On 12/7/2018, I was posted as second officer at Udalguri PS. On that day, in charge SI Jotin Deka, in charge of Bhairabkundo outpost, lodged an FIR with the officer in charge of Udalguri PS. On the basis of the FIR, the OC Udalguri PS registered a case by Udalguri PS case number 153 of 2018 and entrusted me for investigation of the case. In charge Bhairabkundo also produced accused person Somkwar Musahari and Munna Musahari, along with 60 kg of contraband cannabis ganja. A Centro car bearing registration number so and so, which were seen at the spot by him along with miscellaneous diary. Thereafter, I visited the place of occurrence, prepared a sketch map thereof, and sent the samples of seized contraband cannabis ganja for FSL examination. The samples were taken at the spot by in charge Bhairabkunda. On receipt of the report of samples from FSL laboratory gave positive test of contraband cannabis ganja. Then I laid the charge sheet against the accused persons Somkwar Musahari and Munna Musahari under section 20B of NDPS Act. Exhibit 9 is the sketch map. Exhibit 9.1 is my signature. Exhibit 10 is the charge sheet. 10-1 is my signature. Crossed by defense. The informant seized the contraband cannabis ganja and took the samples thereof for sending it to FSL. He also recorded the statement of the witnesses under section 161 CRPC. I only sent the samples of seized contraband cannabis ganja for examination on 13/7/2018. Page 21, PW 10. He is the person who received the initial information. On 12/7/2018, I was posted as ASI of Sonai Khaurang Police Outpost under Udalguri PS. On that day, at around 10 p.m., I received a source information that 2 persons were carrying contraband cannabis ganja in a Sentro vehicle coming from Bhairavkunda side. On getting this information, I recorded GD number 176 dated 12/7/2018 and proceeded to village Bandarguri under the Sonai Khaurang police post and laid an ambush there. I saw one Sentro vehicle coming towards us. The vehicle was stopped, and in the meantime, one person suddenly got down from the vehicle and tried to run away, but he was apprehended. On being asked, the said person identified himself as Somkor Musahari. On being interrogated, he did not divulge anything. Immediately, we also searched the Sentro vehicle which was stopped by us, and in the driving seat, we found one person, and on being asked, he identified himself as Munna Musahari as the driver of the vehicle. On suspicion of carrying contraband cannabis ganja, we checked the vehicle, and in the process, we recovered 2 bags containing suspected cannabis ganja. Page 21. He said, Lordship, 2 cannabis ganja, and he will now describe from where he has found those bags. Page 21, Lordship.
Yes.
6 lines from bottom, Lordship. On suspicion of carrying contraband cannabis ganja, we checked the vehicle, and in the process, we recovered 2 bags containing suspected cannabis ganja. One bag was kept inside the vehicle, and other bag was kept in the dicky of the vehicle. Then I took the accused persons along with vehicle and the bags containing contraband cannabis ganja to our Sonai Khaurang police post. And I also informed the in charge of Bhairavkunda police post and the additional SP Udalguri. So the PW1 was informed subsequently. On getting my information, in charge of Bhairavkunda police outpost came to our Sonai Khaurang police post and seized the contraband cannabis ganja and the vehicle. The accused persons were taken into custody. Then additional SP Udalguri came to our police post, exhibit 2, GD entry, exhibit 2 is my signature. Crossed by defense. I recorded the GD on 12/7/2018 in the morning at about 10 a.m. The FIR of the case was filed by the in charge of Bhairavkunda police, Bhairavkunda outpost. I am not a seizure witness of contraband cannabis ganja. The police personnel who were along with me at the time of spotting the vehicle have not been made seizure witness as regards the vehicle and the contraband cannabis ganja. So the initially the persons who apprehended the vehicle and the contraband, neither of them were made witness in the present case. None of them seizure witness. I did not open the recovered contraband cannabis ganja till handing over to in charge Bhairavkunda outpost at Sonai Khaurang police post. I do not know whether my 161 CRPC statement was recorded by the IO of the case. It is not a fact that I have not recovered 2 bags of suspected cannabis ganja which had been carried in the central vehicle by the accused persons at the place of occurrence. So this is the evidence, Lordship. Now, if your Lordship kindly turns to page 54 of the paper book, Lordship.
Yes,
Here your Lordship will find this is the first weighing machine. Description of article in middle portion your Lordship will find one Salter weighing machine 100 to 500 kg. The contraband is found 60 kg. Whether it is possible to weight in that or I do not know, Lordship, but it is said 100 to 500 kg. And second thing your Lordship will find page 56. Page 56. This is the seizure list whereby the suspected cannabis ganja weight 60 kg. And in column number 5, your Lordship will find that is illegible here. Numbers of sample packets 25 gram each packet, but now no numbering is there in the packets, Lordship. So which packets the subsequent IO sent to the FSL, that is not clear. Whether those are connected with the present case or it is from their Malkhana only, Lordship. Page 56. And there is no inventory as required under section 52A, Lordship.
yes,
This is the evidence, and from the evidence, Lordship, it is, I have placed your Lordship, that initial apprehension was made by PW10. He said he recovered 2 bags, one from the seat and one from the dicky, Lordship. But the PW1, he said, Lordship, he seized 3 bags, Lordship. From where the third bag came, it is not on.
where did you say he sees 3 bags?
Lordship will find in the PW1.
Page number?
In FIR also, the Lordship will find
No,
page
PW
4.
Page 4.
Page 4. Fifth line of the first paragraph, your Lordship will find. Just I am reading the FIR again, Lordship. With due respect and humble submission, I beg to state that
So he said 3 packets.
3 packets.
3 packets can be in 2 bags,
in bracket, it
which
is
can
said
be inside
bosta.
1 sack.
In bracket, Lordship, it is said
Please,
bosta.
please listen. 3 packets
Lordship.
can be put in 2 bags and can be tied inside 1 basta, 1 sack. There is no problem with that.
But that has to come in evidence, Lordship.
You sure that it has
Yes.
not come?
It has not come because Lordship, now PW10, your Lordship will find. Specific, Lordship, will say. PW10, page 21, Lordship. 7th line from bottom of page 21.
1 minute.
Yes.
Yes,
In page 21, your lordship will find, he clearly says, lordship, page 21. From, seventh line from bottom, lordship. On suspicion of carrying contraband cannabis ganja. Lordship, got it.
yes,
We checked the vehicle and in the process, we recovered 2 bags containing suspected cannabis ganja. One bag was kept inside the vehicle and the other bag was kept in the dicky of the vehicle. So he has categorically stated that. And in cross lordship, there is specific question was put, and he said in cross third line lordship, page 22, the police personnel who were along with me at the time of spotting the vehicle have not been made seizure witness as regards the vehicle and the contraband cannabis ganja. Because they were the first person who apprehended. So whether the bags which are subsequently reseized were the same or not, they have to be part of that process, lordship. And second thing, your lordship, already I have pointed out that in page 7 PW 1 say 6 different packets were drawn by for sampling, lordship, as sample. Page 7, third line from bottom. From fourth line it starts. I also took samples from the 6 suspected cannabis ganja weighing about 24 grams each in 6 different packets for sending the same for FSL examination. And PW 8, that is at page 17, he said he received only 3 packets and that is to 25 grams each. There is nothing on record to show that after seizure, those were properly marked and those were properly kept in the safe custody, lordship. That is not there. And regarding that, in page 17, what I have placed, that dry plant materials, that dry plant, these are not only the leaves, because therefore, if I may take your lordship to the definition of cannabis, that your lordship may say, definition, section 2, your lordship will find 2 subclause 3.
Ms. Jahan,
Lordship.
you have to answer this. You prepared? Section,
2. Subsection 3. Lordship.
yes,
Cannabis, hemp, means number A, charas, that is the separated resin in whatever form, whether crude or purified, obtained from the cannabis plant, and also includes concentrated preparation and resin known as hash, oil, or liquid hash. Now, your lordship, may I need to look subclause B, ganja. That is the flowering or fruiting tops of the cannabis plant, excluding the seeds and leaves when not accompanied by the tops. By whatever name they may be known or designated. So it has to.
so what difference does it make whether it is got a flowering or a fruiting top? What
Because
difference?
those seeds and leaves has to be excluded, because in the evidence your lordship has seen that some of the seizure witnesses said that leaves like substance, and the FSL.
So
the
if
director
it is
said-
excluded, then question is,
then question of weight will come, lordship. That
but
proper
60
weighting-
kgs will come below 20 kgs if it is excluded.
Apart from that, lordship, 1 bag has come subsequently, lordship, because initially there was only 2 bags. And whether from the 2 bags the samples were drawn or from the one bag, that is not clear, Lordship.
Yes,
And section 42 is not complied, as your Lordship has seen PW1. Specific question was put to him. Page 8, your Lordship will find in cross
so is 42 directory or mandatory?
mandatory.
Any judgment?
Lordship. Your Lordship's judgment is also there. Your Lordship judgment is also there. The main judgment regarding this is Colonel Singh, Constitution Branch, where it is said also. From page, paragraph 18 onwards, may I read also?
Hmm.
From a careful analysis of the evidence available on record, we find that two accused persons were apprehended by the GPPF personnel at the Kamakya station in the morning of 29/11/2015. However, it is not clear from their evidence as to under what circumstances and by whom the two accused persons were actually apprehended along with the three bags. In the Ejahar, nothing has been mentioned indicating as to who had initially detained the accused persons and at which place. Here also your Lordship has found that PW1 himself claiming that he has apprehended, but what that is different in PW10. PW1, that is the informant, has deposed that the PW4 had told him that he had found the accused persons when they were trying to get down from the train with the bags in their hand. However, during his cross-examination, PW4 has stated that the bags were found inside the train when there was no person available inside. PW4, on the other hand, has stated that the accused persons were apprehended by 12 passengers along with the three bags. But the statement of none of the 12 passengers have been recorded by the IO, nor has anyone been called as witness during the trial. PW3 was the person to whom the RPF persons had handed over the accused persons along with the bags. And he has clarified in his cross-examination that he was not aware as to from where the accused persons had been apprehended. Therefore, there is no clear evidence to indicate as to the circumstances under which the accused persons were allegedly apprehended with the bags in their hand. On the contrary, there are material contradictions in the testimonies of the prosecution witnesses as to the circumstances under which the accused persons were initially detained with the bags. As noted above, the appellant's accused persons had been convicted under section 20B2C of the NDPS Act 1985. One of the essential ingredients of section 20B is that conscious possession of the contraband must be established. As per section 20B2C, the quantity involved must be commercial quantity. The schedule appended to the Act of 1985 provides that in case of cannabis, commercial quantity would be 20 kg and above. Therefore, in order to sustain conviction of the accused persons for an offense committed under section 20B2C of the NDPS Act, it would be incumbent upon to prosecution to prove that quantity is excess of 20 kg of ganja was recovered from the possession of the accused persons. However, we find that prosecution has failed to even prove the same. We say for the following reasons. As per the evidence of PW1, material exhibit 1 is the bag containing 1 packet of ganja, material exhibit 2 is the bag containing 2 packets of ganja, and material exhibit 3 is the bag containing used packet of ganja. PW1 has categorically stated that samples collected by him measuring 24 grams was drawn from material exhibit 3. There is no doubt or dispute about the fact that only one envelope containing sample of 24 grams was sent to the FSL, and FSL report available is also pertaining to that one sample only. From the above, it is evident that for reasons to not discernible from the face of the record, the IO had not sent the samples from the other two bags for FSL examination. What would be significant to note herein that as per the evidence of PW 1 and 4, the total weight of the packets was 35 kgs. According to CJR list, Exhibit 4, the 3 bags containing 4 packets of ganja-like substances were weighing number 1 7 kg, number 2 10 kg, number 3 10 kg, and number 4 8 kgs, measuring 39 kgs in total. PW4 in a CJR witness is a CJR witness, but he has deposed that packets were weighing 35 kgs in total and not 39 kgs. We have also noticed that as per the evidence available on record, the seized packets were measured by means of a manual scale with the help of weighing measuring 6 kgs. We, however, fail to understand as to how the IO could have measured 4 packets of contraband in a manual balance measuring 35 kg in total with the help of a weight measuring 6 kgs. What would also be significant to note herein that although the manual balance had been seized by the IO, yet the same was not been produced before the court. As a matter of fact, it appears from the evidence of PW 3 and 4 that even the seized ganja and bags were not produced before the court during the trial. The prosecution has also not examined the person called Guddu Basfor and the scrap dealer from whom the manual weight balance was taken to measure the seized contraband. Section 42 of the Act 1985 deals with power of entry, search, seizure, and arrest without warrant or authorization. Section 52 of the Act of 1985 lays down the procedure for disposal of persons arrested and Article C. As per Section 55 of the Act of 1985, police is required to take charge of the article seized or delivered and kept in safe custody pending the order of the magistrate. Section 57 provides that whenever any person makes any arrest or seizure under this act, he shall within 48 hours next after such arrest or seizure make a full report of the particulars of such arrest or seizure to his immediate official superior. On a careful reading of the materials on record, we do not find anything on record to show that the requirements of the aforementioned provisions of NDPS Act had been complied in the case. PW1 has stated that the seized articles were deposited by him in the GRPS Malkhana. However, the materials available on record are insufficient for this court to draw a conclusion that the seized articles were kept in proper custody during the investigation. Law is well settled that even in a case coming within the ambit of the NDPS Act, the prosecution would be duty bound to prove the charge beyond reasonable doubt. In the case of Noor Agha, the Honorable Supreme Court has observed that the initial burden to prove the charge lies upon the prosecution, and only when it stands satisfied that the legal burden under Section 54 of the Act shifts. With a view to bring within its purview the requirement of Section 54 of the Act, the element of possession of the contraband has to be established so as to shift the burden on the accused. Similar view has been expressed in the case of Gandhar, alias Gangaram Supra, wherein it has been observed that the presumption against the accused of culpability under Section 35 and 54 of the Act to explain possession satisfactorily are rebuttable. It does not dispense with the obligation of the prosecution to prove the charge beyond reasonable doubt. In the present case, as noted above, we find there is no evidence on record which is indicative of the circumstances under which the accused persons were detained by the RPF authorities along with the bags. Not to speak of conscious possession of the contraband, the prosecution has even failed to prove that the contraband were seized from the possession of the appellant's accused persons. According to prosecution, the accused persons were traveling from the. So this is the fact of that case, Lord. And you, from the record, I have already placed your lordship that PW10 said after seizure, he has not opened the bags. And PW1 says he has seized the bags from the police station itself. So there is no connection where materials to show that these are the bags which were actually recovered from the bag of vehicle of the appellant's lordship. And section 52A is not complied with, lordship. Section 52A, may I? 52A. Which was inserted in the year 1989. okay. Disposal of seized narcotic drugs and psychotropic substances. 1. The central government may, having regard to the hazardous nature of the narcotic drugs or psychotropic substances, their vulnerability to theft, substitution, constraints of proper storage space, or any other relevant consideration by notification published in the official gazette, specify such narcotic drugs or psychotropic substances or class of narcotic drugs or class of psychotropic substances which shall, as soon as may be after their seizure, be disposed of by such officer and in such manner as that government may from time to time determine after following the procedure hereinafter specified. Now, proof where I am relying on lordship, subclause 2. Where any narcotic drug or psychotropic substance has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53 of the 53 or the officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs or psychotropic substances containing such details relating to their description, quality, mode of picking, marks, numbers, or such other identifying particulars of the narcotic drugs or psychotropic substances, or the packing in which they are packed, country of origin, and other particulars as the officer refers to in subsection 1 may consider relevant to the identity of the narcotic drugs or psychotropic substances in any proceedings under this act and make an application to any magistrate for the purpose. Number A, certifying the correctness of the inventory so prepared, or B, taking in the presence of such magistrate photographs of such drugs or substances and certifying such photographs as proof, or C, allowing to draw representative samples of such drugs or substances in the presence of such magistrate and certifying the correctness of any list or of samples so drawn. Number 3, where an application is made under subsection 2, the magistrate shall as soon as may be allowed the application. So here no inventory is prepared. Nothing on record to show that these are the bags which were actually seized from the vehicle of the appellant's lordship. And regarding the 42 lordship, that Colonel Singh judgment is there, that also I am handing over to your lordship. Constitution that judgment lordship that after referring to various judgment lordship, page 35, paragraph 35 lordship. Directions to is there, paragraph 35.
Yes,
So I'm not taking much time of your lordship, just D I am reading lordship, 35D. while total non-compliance with requirement of subsection 1 and 2 of section 42 is impermissible. Delayed compliance with satisfactory explanation about the delay will be acceptable compliance with section 42. Here from the evidence of PW2, he said he admitted that he has not sent the copy to his superior officers. So here total non-compliance. Last one, Judge, I'm placing for lordship. Union of Indian Full lordship. Paragraph 26, lordship.
Paragraph
26, lordship. And 28. Paragraph 26 and 28. Here DK Basu case is referred in paragraph 26. This court in DK Basu versus State of West Bengal laid down the law that if a person in custody is subjected to interrogation, he must be informed in clear and unequivocal terms as to his right of silence. The rule was also invoked by constitutional bench of this court in State of Punjab versus Baldev Singh, wherein it was held. Paragraph 28. This court cannot overlook the context in which the NDPS Act operates, and particularly the factor of widespread illiteracy among persons subject to investigation for drug offenses. It must be borne in mind that severe the punishment, greater has to be the care taken to see that all the safeguards provided in the statute are scrupulously followed. We are not able to find any reason as to why the empowered officer should shield from affording a real opportunity to the suspect by intimating to him that he has a right that if he is required to be searched in the presence of a gazetted officer or a magistrate, he shall be searched only in that manner. As already observed, the compliance with the procedural safeguard contained in section 50 are intended to serve a dual purpose: to protect a person against false accusation and frivolous charges, as to lend credibility to the search and seizure conducted by the empowered officer. The argument that, keeping in view the growing drug menace and insistence on compliance with all the safeguards contained in section 50 may result in more acquittals does not appeal to us. If the empowered officer fails to comply with the requirement of section 50 and an order of acquittal is recorded on that ground, the prosecution must thank itself for its lapses. Indeed, in every case, the end result is important, but the means to achieve it must remain above board. The remedy cannot be worse than the disease itself. The legitimacy of the judicial process must come under a cloud if the court is seen to condone act of lawlessness conducted by the investigating agency during such operations, and may also undermine respect for the law and may have the effect of unconscionably compromising the administration of justice. That cannot be permitted.
Will come, yes, so you have concluded.
Lordship.
Now, you have got to say something?
A little.
My lord,
Yes,
as my learned friend already, my lord, stated all this.
don't repeat anything.
Yes, my lord.
Ah.
So far, my lord, the procedural part, my lord, I will not say anything, my lord. But to solve for the, my lord, contradiction appears from the witnesses, my lord. What I found, my lord, my lord, the place of recovery is a different one and place of seizure is a another one. From the, my lord, evidence, my lord, it is stated that they recovered in front of the, my lord, Suraikong police station.
Hmm.
But they took it in the, my lord, the police outpost, and after that, my lord, the witnesses are, my lord, coming. So, my lord, at the time of the recovery, there is no independent witness in this case, my lord. The whatever, my lord, after, my lord, taken into the, my lord, police outpost, they, my lord, hired those witnesses, my lord. As it appeared from the, my lord, witnesses, because in the cross, they stated that they did not know anything, where from it is brought, how it is brought, my lord, all these things, my lord. And on this regard, my lord, another aspect, my lord, the IO of the case, my lord. IO of the case in his evidence stated that he has not recorded 161 statement, my lord. So 161 statement is recorded by, my lord, it is not stated who recorded the 161 statement, my lord. So in this point, my lord, regarding the material contradiction, my lord, I would like to place one judgment, my lord, which is reported in, my lord, 2018, one Supreme Court cases 222, my lord. So, my lord, on this point, my lord, as from the evidence part, my lord, from the FIR, my lord, as well as from the evidence of the PW1.
Which para you are relying upon?
My lord, para 11, 12, 15, 20, 23, 26, my lord. My lord, this is the judgment, my lord. The session court, my lord, acquitted, my lord. It was, my lord, before the Honorable High Court, my lord. High Court, my lord, reverted the acquittal, my lord. And the Honorable Supreme Court, my lord, stated that, my lord, even material contradiction, my lord, which may be, my lord, minor, but that is, my lord, cannot be, my lord, ignored, my lord. So I'd like to para, my lord, 11, my lord. The learned counsel appearing for the appellant drew our attention to the impugn order passed by High Court and contended that the High Court erred in convicting the appellant for the offence punishable under Section 20 of the NDPS Act. It was his submission that the High Court failed to appreciate that in the absence of independent witness, the evidence of the police witnesses must be scrutinized with greater care, especially when police witnesses contradicted themselves on the issue as to in whose handwriting the seizure memo, the arrest memo, consent memo, and the NCB form were written, and the evidence adduced by the prosecution is not reliable. But I'll go to paragraph 15, my lord. We find that the trial court relied on two main points to decide the matter against the state. First, my lord, no independent witness was examined, and Roman 2, contradiction in the testimonies of PW 4 and PW 6. Then paragraph 20, my lord. From the evidence as mentioned above, it has been stated by Umesh Kumar, PW 4, that when the accused was allegedly apprehended, at that time it was done. He further confirmed that proceeding had been carried out in Searchlight as it was done. However, when the evidence of the complainant PW 6 is considered, it is revealed that according to him, it was not done when the accused was apprehended. Especially, he made it clear that when the accused was seen, the night had broken. He further clarified that the accused had been seen from the distance of 10 meters, and at that time, they were in uniform. It is pertinent to mention here that the complainant PW 6 is very certain that it was not dark when the accused was seen apprehended. It was dark, and the proceeding had to be conducted in Searchlight. By no stretch of imagination, such contradiction can be said to be a bit minor. It is to be noted that the defense version is to this effect that at the instance of one Sri B2, resident of village Guru, the accused had been falsely implicated in this case. when the defense version of false implication, then it was required of the prosecution to have explained each and every material circumstances contradiction which came on record. From the evidence which has come on record, it is quite clear that the place where the accused is alleged to have been apprehended cannot be said to be an isolated one, as the house of the Govind Singh DW2 is situated on the edge of Pathrana village. Thus, the version of the complainant PW6 that independent witness could not be associated as it was an isolated place does not inspire confidence. Moreover, from the evidence of the Govind Singh PW2, the case of the prosecution regarding the apprehension of the accused at a Pathrana bridge while being in possession of bag containing 7 kg of charas becomes highly doubtful, because had he been so apprehended by the police, this fact was to come to his notice, from the reason that his house is situated at the edge of the bridge in which he resides along with his family. Para 13 or 23. In our opinion, the High Court failed to appreciate that the harsher is the punishment, the more is the strictness of proof required from the prosecution, and that failing to associate independent witness at the time of recovery created a dent in the case of prosecution. Para 26, my lord.
All right, so these are all established principles, observations on facts. What else you want to, on
Yes,
this
ma'am.
case?
In this case also, my lord, there is material contradiction, because one saying that 2 packets, my
That
lord,
he has already argued.
already argued, my lord, and so my and from my 313 statement, my lord, the accused, my lord, totally denied the allegation, my lord, he falsely implicated. So this, my case is also.
It's a case of total denial.
Denial, yes. So prosecution has not established the case beyond reasonable doubt, matter.
Please, Your Lordship. Now here, of course, Lordship knows that the police commit certain mistakes that we have to,
Mistakes will be costly.
and we have to like balance it. If I can show other evidences on record, Lordship
No,
can.
no, they see the only issue is the charge has to be proved.
Yes,
Charge
charges.
is not proved, there will be acquittal.
Yes.
Charge is proved, they will affirm it.
Yes.
Nothing more, nothing less.
So I
What
have.
police does not, none of our business. You
So-
tell your government to
Hmm.
train up your police. We are
Because
not
I
concerned.
could find everything, but not the inventory. Inventories and all are not prepared. Malkhana register, of course, the numbering and all are there. But other formalities, as I have shown to your Lordship the other day, that in some cases, it becomes directory, not mandatory. So that is the only submission that I can rely upon. But first of all, what were the number of packets?
How much was the quantity seized and
Huh.
where is the evidence to show that?
Yes.
First take us to that.
First, that would be the basic thing. 60 kg, what they say is that.
Hmm.
And whether it was in their conscious possession and what were the number of bags that were seized. Now I'll address on that issue first. Now, what it seems from the facts is PW10 was the first one who got the information about this drugs being carried. He got from a source information, then he immediately had made a GD entry, and then he informed his superior officer. This is correct in his understanding, because 42(1) says that the officer who gets the information, he should write down in the GD, he should make a GD entry, and then he should within 72 hours should report it to a superior officer. Now here, he got the information, he wrote the GD entry, and he informed IC Bhairav Kundu. He was SI Sonai something. So he got the information, he wrote it down, then he immediately informed the IC Bhairav Kundu along with his staff came to the place. They laid an ambush there. Then they apprehended, they saw the vehicle. One tried to escape from the vehicle, they apprehended, and the other was the driver who was inside, and both of them were apprehended along with the articles. This, the first one, the SI Sonai, he said there were 2 bags. But Lordship will see SI Sonai and the ASI Sonai in charge Bhairav Kunda and the other staff members were there. ASI said there were 2 bags. ASI, I'll just read out that particular line, PW 10. He said, on suspicion carrying cannabis, we checked the vehicle and in the process, we recovered 2 bags containing suspected ganja. But this is, Lordship will find 5 lines from the bottom, PW 10, page 21.
Yes.
On suspicion of carrying contraband cannabis, we checked the vehicle and in the process, we recovered 2 bags containing suspected ganja. 1 bag was kept inside the vehicle and the other bag was kept in the dicky of the vehicle. He said that, but the IC Bhairav Kunda, in charge Bhairav Kunda, who was a superior officer, he was examined as PW1 and he said, Lordship will see, he said 3 packets, 6-7 lines from the top. And in fact, a few lines from the top, Lordship will see that all of them were together there when the vehicle and the ganja were caught. Now, on that day, 10 a.m., I received information from IC Sunai Gyasuddin Ahmed that 2 persons were coming from Bhutan towards Udalguri carrying suspected. On receipt of the information, I recorded Bhairav Kunda GD. He also recorded. And along with my staff and IC Sunai, he is Gyasuddin, conducted Naka checking in front of outpost, Sonai outpost. We conducted check upon the Centro car where the present accused persons were traveling and found 3 packets suspected ganjas weighing 60 kgs. So he in very clear terms says that it was 3 packets. On being asked, accused disclosed their names and all. So he said 3 packets. He did not say that it was in dicky or in the vehicle. He said 3 packets and the junior officer, the ASI of Sonai, he said 2 packets. And thereafter, Lordship will see, even in the FIR, this was lodged by Jotin Deka, PW1, PW1, and he said it was 3 kgs, it was 3 packets Bosta. In the bracket, it was Bosta, means it is a jute bag or something. So he also, in the FIR also, it is written 3 packets. Even and samples that were made were 6 packets. 6 packets, Lordship will know, 3 packets in original and 3 packets in duplicate. This is how they make it. 3 packets they keep in Malkhana and 3 packets they send it for FSL. That is how 6 packets. So this, in totality of these evidences, one can gauge that it was 3 packets, 6 packets sample, and 3 packets the senior officer says, as well as the FIR. So these 2 packets, on what ground he said, this is not discernible. Compare if we see the other evidences on record. The independent witnesses and the things were weighed at the spot itself. This is what the independent witnesses have also said. PW1 had said at the last line at page number 7, he said, I also took samples weighing 24 grams each in 6 different packets for sending in the same to FSL. So 3 packets in original and 3 packets in duplicate. And those were sealed at the spot in the presence of the witness. Centro vehicle, he also seized. And he also said that he got authorization from the DSP. So as far as the procedures are concerned, those were, in my humble submission, has been fulfilled here. Thereafter, MR number is there. Lordship will see the Caesar list once. Caesar list of the 6 packets. Page number 56. Page number 56 on the top, after Caesar list, Lordship will see this MR number 86 of 18. The Lordship get it on the top. This is Malkhana register number 86 of 18. Here, 3 packets of suspected ganja weighing 60 kgs.
See, the problem is 3 packets, the PW3 has also said 3 packets, the Cesar is on. Then why did the person who actually detected it first speak about 2 packets?
This is what I cannot discern even, but they did not raise that question in the cross-examination. But cross-examination, he simply said, the police personnel who were along with me at the time of spotting the vehicle have not been made Caesar witness as regards the vehicle and the cannabis. I did not open the recovered cannabis, still handing over to in charge. This, of course, that is not, I don't find anywhere in the evidence why he said 2 packets, one in the vehicle, one in the dicky. But otherwise, all other evidence says that it is 3 packets. And in the FIR, it's written Bosta. That means 3 Bostas. And he said, I did not, PW10 said, I did not open the recovered contraband cannabis, still handing over
Where
the
is
same.
LCR? Just give her the LCR.
Lordship, I have the LCR.
Oh, just see, is it in vernacular, PW10?
No, it's in audio, it's in English. PW10. No, it's in English, it's in English only. It's in English. This is
And also
original.
it's mentioned 2 bags.
2 bags containing suspected ganja, 1 bag was inside the vehicle.
So he says 2 bags, the others said 2 packet,
3 packets.
3 packets. So can 3 packets not be fitted in 2 bags?
That evidence again is not there. And 3 packets and bracket, it's written ganja. Of course, FIR is not a substantive piece, but that evidence is not there that 3 packets packed in 2 bags. Let me see the 161 statement if he has said anything. PW10. PW10 or naam kya isme? Gas is in, no? Gyasuddin, his 161 is there. We have got there. Here, kohe bari bani tumi sosun. He yapa kohna, kena yapa kohna. DSP. There are 2 packets, question.
2 packets.
Person. Cotton. 2 packet cotton. No, Azar. It's a small statement of 161 of Gyasuddin. In charge, how?
মই আজি 10 বজাত ভূটানৰ পৰা গাঞ্জা অহাৰ খবৰ পাই দৈনিক পঞ্জীয়ক 276 হতে দৰজ দিওঁ আৰু এই সন্দৰ্ভত এছপি এডিশনাল এছপি ডেপুটি এছপি খবৰ দিওঁ ইয়াকে পাই ওচি আৰু আইচি ভৈৰৱকুণ্ড অপি খবৰ দিয়াৰ উপৰিও ঊৰ্ধ্বতন বিষয়াক নিৰ্দেশ মৰ্মে আইচি ভৈৰৱকুণ্ড অপি সহযোগিতাৰ বাবে মাতি পঠাও কিন্তু আইচি ভৈৰৱকুণ্ড আহি পোৱাৰ পূৰ্বে মই নাকা চেকিং আৰম্ভ কৰোঁ নাকা চেকিংত এখন চেন্ট্ৰ গাড়ীত 2 জন লোক 3 পেকেট লৈ আহি থকা অৱস্থাত পাই মই ভাংসহ 2 জন ব্যক্তিক গাড়ী সহ পিপি লৈ আহো তাৰ পাছত আইচি ভৈৰৱকুণ্ড আহি পায় আৰু ডেপুটি সুপাৰিনটেণ্ডেণ্ট মহোদয়ৰ নিৰ্দেশ দিয়া মতে মই সোমাই চকৰ পৰা জোখমাখৰ বাবে সামগ্ৰী লৈ আহো আৰু আইচি ভৈৰৱকুণ্ড থানাত সেইখিনি জব্দ কৰে তাৰ পাছত ডেপুটি এছপিৰ পৰা মহোদয়ৰ মতে ৰিটেন অথৰিটি পাই মই ভাং গাড়ী আৰু সিহঁতৰ টকা পইচা জব্দ কৰোঁ মই ভালদৰে জানো যে দুয়োজন মই ধৃত অপৰাধী habitual
Habitual.
cannabis
cannabis.
smuggler হয়।
Oh,
সিহঁতে বহুত দিনৰ পৰা মোৰ চকুত ধূলি দি গাঞ্জা সৰবৰাহ কৰি আহিছিল।
মই,
সেইমতে মই
সেইমতে মই
চোৱা নিয়োগ কৰি দুয়োজনকে আৰক্ষীৰ জালত ধৰা পেলাও। মই দুয়োজনক ভালদৰে সোধ-পোছ কৰিছো আৰু দুয়োজনে নিজৰ অপৰাধ স্বীকাৰ কৰিছে। এই সন্দৰ্ভত যতীন ডেকাই সিহঁতৰ সোধ-পোছ কৰাৰ প্ৰয়োজন নাই। সিহঁত দুয়োজনৰ ওপৰত FIR দিবলৈ মই নিৰ্দেশ দিছো। মোৰ ক'ব লগা ইমানেই।
এইখিনি। In fact, in 161, he said 3 packets. And he did not talk of dicky and the main vehicle. He simply said 3 packets. I'll mark it, Lordship can see it once. One 61 statements, of course, is not reliable, but to see the veracity of the witnesses, sometimes that needs to be taken recourse to. So as far as packets are concerned, what I think is coupled with the Caesar list, the statement of PW1 as well as the FIR, it shows that 3 packets were seized. These 2 appellants were inside the vehicle. One tried to run away and one was inside driving the vehicle, and therefore they did not say anything in their 13313 statement. So conscious possession by these persons, in my humble submission, is established. Now 60 kgs. Now 60 kgs, PW1 said that he had weighed it in the spot itself. PW1 said, Lordship will just see 5 lines from the bottom. I weighed the suspected cannabis at the place of occurrence in presence of the witness and I seized it. I took samples for 24 grams each in 6 different packets for sending the same to FSL. The said samples were also sealed in the spot in presence of the witness. I also seized central vehicle. This is sealed at the spot itself. Now even the independent witnesses have said, PW2 has said that they had taken the weighing machine, and he also said 3 sacks in my presence. That 3 bags is also established by PW2. He said weighed suspected cannabis kept in 3 sacks in my presence, and I put my signature. 60 kgs to Kina Kusala. Now PW10 statement about the 60 kgs. The 60 cases, of course, is stated in the FIR only, not 60 cases. 60 cases of authority. FIR is there. Lordship will see the FIR which was being carried in the vehicle. 3 suspected cannabis, 60 kgs, which was being carried in the vehicle. Centro. So he had said PW10, 1 had said it was 60 kgs. And in his examination in chief, he also said, and found 3 packets suspected cannabis weighing 60 kgs. PW1. From 100 to 600. Caesar list, yes.
Where is the evidence of 60 kgs?
60 cases evidence only in the FIR. PW1 said 6 packets weighing 60 kgs. PW1 said at page number 7, 5 lines from the top, in front of, so we conducted check upon the Centro car where the present accused persons were traveling and found 3 packets suspected cannabis weighing 60 kgs.
Yes.
And the electric weighing machine, PW2 had said that the IC Sonai came to my house, came to my shop and seized my electric weighing machine and weighed suspected ganja kept in 3 sacks in my presence, and I put my signature. He had weighed by seizing his electronic weighing machine. Then PW5, another weighing machine to the Muslim, that was some suspected cannabis. And then PW7 had also said, about 1 year ago to my jewelry shop, he came to my jewelry shop. Police asked me to hand over mini digital measuring scale and also asked me to accompany to the Udalguri police station. There, of course, he had measured 6 packets of that sample, 24 grams.
That mini digital is for samples.
This is for samples. Only PW2, this is for the bags, the sacks. This is electronic weighing machine. And Lordship may then go to the the Caesar list. Page number 54.
Yes.
This is salter weight machine. This is salter weight machine. This is, of course, it's a hand kind of a machine where something is put and can be measured. And this is, of course, 100 to 500 gram. I've checked in the Google even kg, 100 to 500 kgs. I've checked even in the Google. It's, in fact, it runs from 1 to 100 or to the 500. So although it's written 100 to 500, 60 kgs can be measured in this all salter weight machine. So this was done at 11:45 AM, 12th of August. With this, they have measured and they have found it 60 kgs. And nowhere in the defense.
What does it do with a 100 to 500 kg weigh machine in a jewelry shop?
This is PW2. I think, I was at my jewelry shop, came to my shop and electronic weighting machine and weighed suspected ganja. Normally it is there in drilling or welding shops, but it is a jewelry shop and they came and took it. Apurva Bosho, I have to hereby seized. The place of Caesar is Apurva Bosho. Apurva Bosho is one of the signatory here. He is one of the witnesses. So this weighing machine is seized from Apurva Bosho only, PW2.
So both PW2 and PW7 are both jewelry shop owners. 500 kg weighing machine is a jewelry shop
Little
in Udalguri.
unusual. Normally it is there in welding shops, drilling and all those,
Hmm.
but
100 kg gold, you must be a very rich man. Huh?
not,
Who buys 100 kg gold? from Udalguri?
yes. Somehow,
Something
somewhere.
is amiss. The fact of the matter is your IOs don't know how to investigate in NDPS case.
This is,
Let us put it at rest there.
this is there.
Till the time the departments wake up,
Mm.
we will have this kind of anomalous results. What can be done?
Whatever is there that I can show otherwise, in the Caesar list, that illegible part I have seen, it is 6 numbers of sample packets. As far as sample packets, it is 6 number of sample packets weighing 25 gram each. So as far as 60 kgs is concerned, there is nothing on record that it will not be that. Because Caesar list shows, even the independent witnesses have said that in front of me, they have weighed it. PW1 said on being weighed, it is 60 kg. PW10 said it was 60 kg. FIR said it is 60 kg. So 60 kg, there is no contradiction as such. And this was not put up, this was not addressed in the defense, by the defense. Nothing is, it can be elicited. So 60 kgs of cannabis recovered from the vehicle where these 2 persons were there. In my humble submission, in these facts, it is established. That is there. After that, the procedures that needs to be followed. There are, of course, some flaws here and there, but MR number is there, 86. Malkhana Day, it is registered. 3 packets were kept in Malkhana and 3 packets were sent to the FSL. FSL report is there, cannabis. Of course, FSL, what
Is
the
it-
learned Fed
is
said.
it necessary that there should be an order of the magistrate to keep it in Malkhana? In an
This
NDPS case?
this is there in section 52. 52 again is a directory, what I have shown to your lordship on the other day. Here, 42 requires that he should immediately report to his superior officer within 72 hours. 52, of course, said that base rate needs to be there. But this again, 52A subclause 2. On the other day, Gurbakshing, I have placed this in certain facts of the case, it can be directory, not mandatory. But again,
Gurbakh Singh also says that the
Huh.
IO cannot ignore it.
ignore it. IO cannot ignore it. That is, of course, there. But here, superior officer was given, DSP gave an authority letter, IC Bhairab had said they have seized. In front of independent witness, things were sent to the Malkhana, were sent to the FSL.
Who are these Caesar witnesses, independent witnesses?
These jewelry people, they have said that in front of me, they have weighed PW2. They have taken my weighing machine and they have weighed. And Ganja, Lordship will see one point that he has raised. The FSL report shows that the seats may be there and all. The FSL report, Lordship will go to the FSL report at page 17. What they say is all have given positive tests for ganjas. In his cross-examination, he said, I have sent back the remnants of the sample to the forwarding authority. I have not specifically mentioned about the flowering top or fruiting top of the sample. I mentioned as ganja, which signifies both flowering top and fruiting top. In fact, in the definition of
That's all right.
Huh.
How do we presume that the 6 samples were not drawn from one packet? Invite our attention to something
because
which clarifies that.
IOD, PW1 said each.
Hmm.
Lordship will see the word sentence. I also took sample from the seized suspected cannabis ganja weighing 24 gram each in different packets
Hmm.
for sending the same for FSL.
Correct. So where is the material to show that each
Yes.
24 gram belong to each packet?
Now, he should have further clarified and said 3 packets from 3 samples from 3 packets. Then not in so many words, what can be done with our police officers? At least 6. 3 packets, 6 samples.
Hmm. Yes, anything else you want to say?
Inventory, of course, is not there. Malkhana register is there. 52 and 57 are, of course, police cannot ignore. But again, it's not mandatory. If we see that the evidences are good enough, Lordship can ignore that part. But 6 packets again, of course, not in so many words, he didn't say. Let me see the cross-examination again. He exhibit 3 issued by so-and-so, I reached, I did not. No, he did not say. I had not specifically mentioned the nature of packets in which the seized contraband ganjas had been kept. I seized the suspected ganja from Sonai police outpost. He did not say, of course, 3 packets from each, 3 samples from each 3 packets. That in so many words is not there. 161, Lordship, I have marked 2 bags can be ignored. This is my humble submission, otherwise nothing is there.
What is your prejudice? Supposing we find that there was actually interception, seizure of ganja. What is your prejudice if a particular order from magistrate has not been, show us your prejudice.
Before coming to that, just I am replying to my learned, what my learned senior officer said, Lordship. First, he said about Lordship senior or junior, because PW1 is senior, so he has taken over the charge. There is
Right, you
nothing on
please
record.
show it, but Mr. Ahmed, let's be, it's difficult to say this. We know what has happened, we all know.
Lordship.
You are only playing on the loopholes of the investigation, which you are entitled to.
Lordship.
But unless you can show prejudice, we will ignore loopholes. We are making it very clear. to you.
Lordship.
If we are satisfied that these things have happened,
Lordship.
there has been actually seizure
Right.
and recovery, and the other evidence clearly shows that this is what has happened. Then only because some record has not been maintained, some procedure has not been followed, that will not be a ground to set aside conviction unless you can show what was the prejudice.
No, I will place for your Lordship, the provisions which I am relying on are mandatory. That is what I am placing for your Lordship. First of all, just I am making clear about the 2 bags or 3 bags. But my learned friend has said that in 161, he has said about 3 bags. But here your Lordship will find at page 22, a specific question was put to him to ascertain that aspect, whether actually 3 bags or 2 bags. So the defense put a specific question and he replied to that at page 22. I do not know whether my 161 CRPC statement was recorded by the IO of the case. Page 22. Page 22. So he has not disclosed anything about the 161. So there is no occasion for the defense counsel to ascertain whether the wording which is written by PW1 as 161 is correct or the deposition which is stating before the court, Lordship. And this
No,
witness,
no, what is the point you are trying to make? Page 22, which line?
third line from bottom, Lordship. I do not know whether my 161 CRPC statement was recorded by the IO of the case.
So what does it mean? That means it was not recorded.
His Lordship not saying specifically whether it was recorded or not.
So therefore,
So-
is the inference that it was not recorded by the IU?
No, Lordship, I'm not saying that. I'm saying, Lordship, because he did not say specifically, therefore the accused did not get any chance to say whether the actually 2 packets were recovered or 3 packets were recovered, because 161 says differently. And he as a witness before the court,
No,
deposed
how
the
can
2
it be?
packets.
The case diary did contain the 161 of this witness.
Lordship, until and unless he said that this is my statement,
Hmm.
I cannot cross-examine him on an aspect.
No, but did you show him the statement? It is one thing to say that I do not know whether the IO is recorded. And another thing to show the statement and say that is this your statement? Both cannot be equated.
But he
These are
said,
two
Lordship,
different things.
I do not know whether my statement is recorded or not.
No, Mr. Ahmed, whatever else may happen or not happen, that we don't know. What will be the outcome of this case?
Right.
We don't know that. We'll go through the record. But the things you are trying to link up,
Lordship.
that we are not accepting it. What he says is that I do not know.
Yes.
I do not know because there is a time lag between the recording of 161 and for some reason, whatever, he may not be able to recollect.
Lordship.
That is another thing.
Exactly.
But that certainly doesn't mean that his statement was not recorded by the IU.
Even we exclude that
And
part.
that
Lordship.
too, when the case diary is there and which shows his statement, if the statement was put to him and he would have said that this is not my statement,
Yes.
then he could have gainfully argued this, but not without putting that.
Even if we exclude that part, Lordship, if here in the examination in chief, he said two bags, one from the inside the vehicle and one from dicky of the.
That's right, PW 10, yes.
And he is not declared hostile, Lordship.
Hmm.
And until and unless he is declared hostile, prosecution is bound by his evidence, Lordship.
Hmm.
And just I'm taking to your Lordship to PW4, another independent witness.
No, but those submissions you are making from some of the judgments of this court.
No, Lordship, no. I'm just placing about the bags. PW4 is saying about one bag. He is independent witness. So I'm just placing before Lordship there.
PW 4 is saying about one bosta.
Yes, one jute
They
bag.
are talking about 3 packets or 2 packets.
That is what I'm submitting to your Lordship, that prosecution case is not clear whether one bag, two bag or three bag.
No, that's the question we are asking you. 3 packets, correct,
Lordship.
were put in 2 bags, which was then put inside 1 sack. You did not contradict them.
No, here just what I'm, my argument for Lordship is that here the sentence is stricter, Lordship. So they have to prove the first case that there were actually 3 bags or 3 packets inside 1 bag. They have to prove it first. The burden, initial burden is on them, Lordship. There is nothing on record to show, because if your Lordship sees the evidence of PW1, he nowhere says that there were 1 bag and from that he has took out 3 packets. He simply says, Lordship, 3 packets in the were kept in the vehicle. Just I am taking your Lordship to PW1 again, Lordship. Page 7. In middle portion of his examination in chief, your Lordship will find, we conducted check upon the Centro car where the present accused persons were traveling and found 3 packets suspected cannabis weight 60 kg. On being asked, the accused person disclosed their names and also. We recovered the suspected cannabis which was kept inside the Centro car. And your Lordship may now kindly turn to page 8, last line.
So in his cross, PW1 says search and seizure was made in the place of occurrence.
Yes.
But you said it was made in the police station.
No, last line, Lordship may kindly see. Last line of cross. I seized the suspected cannabis ganja from the Sonai Taurang police outpost. I'm just placing the.
That's all
conduct-
right. He is used the seize means he took over possession probably.
to government. So he do not know from where the articles were recovered, how many articles were there. He does not know anything, Lordship. The initial person who is the PW10, Lordship, he is deposing before the court on oath that 2 packets were recovered, one from the car and one from dicky, Lordship. And that witness is not declared hostile by the prosecution. That is what I am placing. And second aspect, Lordship, what my learned friend has said, that preparation of inventory is not mandatory. Just I am taking to section 52A, your Lordship will find the word used here is shall, not may, Lordship.
Is there any decided case law on this?
Section
Any
52.
decision 52A is mandatory? You said this decision of this court holds that, it doesn't hold that. Is there any decision which says 52A is mandatory?
It is mandatory. I can place before your Lordship.
Where is the
After-
decision?
After vacation, after Lordship break, I will place before your Lordship.
After?
After break, Lordship. No,
You know or you want to try out?
I have read as per.
Then we'll have it day after tomorrow. We'll close it. Day after tomorrow, part heard Mr. A.M. and Learned Counsel and Mr. Jiuddin Learned Counsel appearing for the appellant. You are in appellant in item number?
Item number 5, Lordship, criminal jail appeal.
The appeal in Jiuddin in item 4,
Jail appeal
Also,
34
Mr.
of
S. Jahan, learned APP Assam appearing for the state in both the appeals. Hard in part, registered to list the state again day after tomorrow, that is give the date. Can you give us a brief written note?
Lordship,
Summary?
yes. Main points are.
Yes, yes. You show us that it is mandatory.
Lordship,
So far, the judgments we have seen, it only says these are all directory. But ordinarily, it should not be ignored.
And 42 is also there. 42 is not also not complied with. That is also there. That is mandatory. That I already have placed Colonel Singh judgment.
Yes, but that is a surprise. There is a chance recovery. Na? In
No,
the Naka, suddenly they got it.
no, they have to subsequently, they have to comply with. Because the Colonel Singh judgment says delayed compliance will be accepted, but total non-compliance will not be accepted.
That's correct.
That is.
Lordship.
All right. Yes,
Alright.
next
All
matter.
right.
Item 6.
Please, your lordship, my lord, this is the appeal by the state, my lord. Appealing the order dated 10/1/2019 at page 34. The issue is that, my lord, the writ petitioner, so he is the father of a, my lord, child with autism with mental retardation. So he was transferred from Guwahati to Silchar Medical College. On that ground, my lord, he approached this honorable court entirely challenging that order, my lord, his transfer order, my lord. So this court initially, my lord, this court directed the respondent authorities to consider the case of the petitioner and pass a speaking order. That order is as page, my lord, 48. Forty-seven starts at page 48, my lord.
48 of the paper book.
No, 48 of the memo of appeal, my lord. Page 48.
Page 48, it says with some other order of this court.
Yes, my lord. The order of the court in the earlier writ petition, my lord. So this court directed the state government to consider the case of the petitioner and to pass a speaking order regarding his transfer, my lord.
This order is not under challenge.
Page 48, my lord.
The another order has been under challenge.
Page 48, the operative portion at page 51, my lord.
So what order was passed pursuant to the order dated?
Pursuant to this order, my lord, at page 53, my lord. Annex 8, my lord.
Hmm.
So challenging that order, the writ petitioner preferred the writ petition, my lord. Which has been disposed of by order dated 10/1/2019 at page 84.
Mallet, before going to the merit of the case, Mallet,
So this order was challenged subsequently.
Yes, my lord. So that order, writ petition order at page 84, my lord. Impugn order appeal against, my lord. Page 84, my lord. The operative portion is that, my lord, the honorable single judge has been pleased to direct the respondent authorities to issue a fresh order interfering with the speaking order, my lord.
So issue a fresh order, what is the problem?
Because, my lord, now the appeal has been preferred on the ground and, my lord, because the government of Assam, there is no such policy, my lord. That, because, my lord, the person petitioner, my lord, he has been serving in GMCH, my lord, right from his initial posting. So by now, my lord, he has completed 24 years of service in GMCH only, my lord. And there is no any policy of the state government that, my lord, any person having this type of children, my lord, he should be accommodated in one place. So there is no any policy, my lord. So in absence of that policy, and otherwise also, my lord, the because there are three guidelines as directed.
No, Mr. Bora, what we are asking you is, the learned single judge has given you the liberty to pass a fresh order.
Fresh order, my lord.
What is the problem then?
Problem is that, my lord, because
You are the one who have kept all this thing pending. This was done in January 2019.
yes, my lord.
You could have passed that order 5 years back.
Yes, my lord.
Why are you, what is the problem here?
Problem is that, my lord, because by passing a fresh order, my lord, the petitioner has to be accommodated in Guwahati only, my lord. And
Does this order say so?
my lord, the observation, my lord, observation says so, my lord.
My lord,
No, no.
he is not up to date information, my lord. He doesn't have the up to date information. By virtue of this, this government order, 31st of December 2022, he has already been transferred with promotion to the Kokrajhar. Now he is hanging with these old cases, my lord. That has already been.
I don't have that objection.
Who has been transferred?
Yes, my client, my lord, this Dr.
My lord, he should
Bhubaneswar.
have told me earlier. I was talking to him.
It is your duty to get the information.
All right. Now he has joined.
He has joined on
This has
6/1.
become-
Yes.
Then this has become infractions.
Yes, my lord.
In
it is
process.
okay.
Heard Mr. DP Bora, learned counsel appearing for the appellant. Also heard Mr. P. Chetri, learned
Yes, my lord.
counsel appearing for the lead appellant. Read petitioner oblique respondent. This appeal has been preferred by the state assailing the order dated 10/1/2019, passed by the learned single judge in WPC number 4750 of the 2000.
By virtue of that, he was accommodated, my lord, in GMCH by that order, my lord.
Whereby
Uh,
the learned single judge
the order to.
had disposed of the writ petition filed by the respondent challenging the order of transfer dated 18/7/2018 by providing that the respondent authorities may pass a fresh order in case of the respondent in the light of observations made in the order dated 10/1/2019. Mr. Bora submits that if the order dated 10/1/2019 is maintained in its present form, then the authorities would have no option but to continue with the posting of the petitioner at the GMCH at Guwahati. At this stage, Mr. Chetri has produced a copy of the notification dated 31/12/2022 issued by the Commissioner and Secretary to the Government of Assam, Medical Education and Research Department.
In serial number 4.
Huh?
Serial number 4, Dr. Bhubaneswar.
Which goes to show that the respondent, Dr. Bhubaneswar Saikia,
Has been promoted.
has been promoted to the post of professor and posted at Kokrajhar Medical College and Hospital, Kokrajhar.
And he- And lastly, I have stated my lord, joining that and join last six, that bottom, my lord. The first page bottom, my lord, 6-1.
According to Mr. Chetri, the respondent has already joined at Kokrajhar on 6/1/2023. Full stop. If that be so, the writ appeal has evidently become infructuous. Full stop. By retaining a copy of the notification dated 31/12/2023 in the record of this case, we therefore close this writ appeal as infructuous.
Lord.
I'm appealing number 2, my name.
Mr. B. Mohanto is present on behalf of the respondent number 2. B. Mohanto is present on behalf of respondent number 2. Who is the respondent number 2?
Dr. Lina Talukdar. She is also doctor. She has been accommodating James. In respect of.
All right,
Deeply over.
yes.
7, 8 and 9.
May it please your lordship, my lordship, may kindly agenda matter for the day, my lord. On behalf of
This
R.
case-
Mazumdar.
In this case,
No,
Argumenter, he has no role.
No.
He is a formal party. Because my challenge is that, my lord, the degree of the private respondents, my lord, they are not recognized by the NCT. The NCT is before lordship, and the private respondents are also there.
But if a council asks for little accommodation,
Then day after tomorrow, my lord,
huh?
day after tomorrow, my lord. I have some urgency, my lord, because
Next Tuesday, my lord, I will be out of station from next Thursday. Next Tuesday. Next Tuesday, not Thursday.
All right.
24.
Miss, you are appearing for whom?
I'm caring for R. Mazumdar, my lord. H.
Armanandar
Terang.
is a party.
No, my
Then
lord. He's
he's
the
a-
standing council of secondary education, my lord.
Miss H. Terang, learned,
Terang P, my lord.
Terang P.
P. Yes, my lord.
Learned Council submits that Mr. R. Majumdar, Learned Standing Council,
It's got some personal difficulties. today.
Secondary Education
Yes, madam.
Department, Assam, has some personal difficulty, as a result of which he has not been able to come to court today. As such, these matters be taken up on any other day. Full stop. The Learned Council for the other parties have expressed urgency in the matter. Be that as it may, on the request of Ms. Tarang, the hearing of these matters stand adjourned till, what is the date? 24th of January 2023. Registered to list these cases accordingly. No adjournment on that day.
Yes, madam.
Okay, so part 2 hearings.
Also hearing. Mr. Nibutan, item 1. 2. 3 to 6. 7 to 11.
And we'll rise for the day. Yes.
Lodge.